Finding an official court document in your mailbox can be a jarring experience. Your heart might race, and a dozen questions probably flood your mind. But take a deep breath. Receiving court papers doesn't mean you've lost or that you've done anything wrong. It simply means a legal process has begun, and you are now a part of it. This is your opportunity to tell your side of the story. If you've been served with a plaintiff's claim from the Ontario Small Claims Court, this guide is for you. We'll walk you through the essential steps, from the moment you open that envelope to preparing for your first major court appearance. We'll demystify the forms, explain the timelines, and provide a clear roadmap so you can navigate this process with confidence. Remember, this video is for informational purposes and is not a substitute for legal advice from a qualified professional. Your first task is to become an expert on the document you've just received. This is the plaintiff's claim, and it is the foundation of the entire lawsuit. Read it through once to get a general sense, then go back and read it again, this time with a pen and notepad. Pay close attention to a few key areas. First, identify the plaintiff, the person or company suing you. Next, locate the reasons for claim section. This is where the plaintiff outlines their story. They will detail the events they believe entitle them to a legal remedy from you. As you read, make notes. Do you agree with the facts presented? Are there dates, names, or events that are inaccurate? Finally, look for the amount claimed. This is the specific amount of money the plaintiff is asking the court to order you to pay, plus any costs for interest or legal fees. Understanding exactly what the plaintiff is alleging and what they are asking for is the critical first step in building your response. Now let's talk about the most important element at this stage: time. The court system operates on strict deadlines, and the clock starts ticking the moment you are served with the claim. In Ontario, you generally have 20 calendar days to file a defense if you were served within the province. If you were served elsewhere in Canada or in the United States, that period extends to 40 days and to 60 days if served anywhere else. These are not suggestions, they are firm rules. The 20-day period includes weekends and holidays, so you must count every day. Missing this deadline has serious consequences. If you fail to file your defense in time, the plaintiff can ask the court to note you in default. This means you lose your right to defend the claim, and the court can issue a judgment against you without ever hearing your side of the story. So, the very first thing you should do after reading the claim is to calculate your deadline and mark it everywhere. On your phone, on a calendar, on a sticky note on your fridge. Do not let this date pass without taking action. Faced with a claim, you have several options. Your path will depend on your perspective of the situation. First, you can choose to defend the claim. This is the most common response. You do this by preparing and filing a document called a defense, where you formally respond to the plaintiff's allegations. You might deny all of the allegations, or you might agree with some parts of their story, but disagree with others. Within your defense, you also have the option to file a defendant's claim. This is essentially a counterclaim, where you allege that the plaintiff actually owes money or property. This is a separate claim that will be heard alongside the original one. Alternatively, you might review the claim and realize that the plaintiff is right. In this case, you can choose to pay the amount claimed directly to the plaintiff or file a form admitting to the claim and proposing a payment plan. The one option you must avoid is doing nothing. As we just discussed, ignoring the claim will almost certainly lead to a default judgment against you, which can affect your credit and lead to enforcement measures like wage garnishment. Once you've decided to defend the claim, it's time to become a detective. Your memory is a good starting point, but a strong defense is built on a foundation of solid evidence. Your goal is to find anything and everything that supports your version of events. Start gathering all relevant documents. This includes contracts, invoices, receipts, letters, and any other paperwork related to the dispute. Think digitally as well. Go through your emails, text messages, and social media messages. A single message that confirms a date, an agreement, or a conversation can be incredibly powerful. Don't forget visual evidence. If the dispute involves physical items like a damaged car or a poorly done renovation, photos and videos are crucial. If you have names of potential witnesses, people who saw or heard something relevant, write down their names and contact information. The key at this stage is organization. Don't just throw everything into a box. Sort your evidence chronologically. Create a timeline of events. This will not only help you write your defense, but it will be invaluable as the case progresses. With your evidence organized, you are ready to draft your defense. This is your formal, written response to the court. The goal is to tell your story clearly and concisely. Using the official defense form, you must respond to each allegation made by the plaintiff in their reasons for claim. Structure your defense logically. Go through the plaintiff's claim paragraph by paragraph. For each point they make, state whether you admit it, deny it, or have no knowledge of it. If you deny an allegation, you must explain why. This is where you present your version of the facts. For example, if the plaintiff claims you failed to pay an invoice on March 15th, your defense might state, the defendant denies the allegation in paragraph 4. The defendant states that payment was made in full via e-transfer on March 14th and attaches a copy of the transfer confirmation as evidence. Keep your language simple and professional. Stick to the facts. While the situation may be frustrating, this is not the place for anger or personal attacks. You are writing for a judge, and a clear, factual, and respectful tone is always more persuasive. Your written defense is complete. Now you must officially file it with the court. In Ontario, you have two primary options: filing online or filing in person. The Small Claims Court e-filing portal allows you to submit your documents and pay fees electronically from anywhere, 24/7. This is often the most convenient method. Alternatively, you can go to the specific courthouse location listed on the plaintiff's claim. You will need to bring multiple copies of your defense, typically one for the court, one for yourself, and one for each plaintiff. A court clerk will review your documents for completeness, stamp them as filed, and give you back your copies. The main form you will be filing is Form 9A, the defense. If you are also making a claim against the plaintiff, you will file Form 10A, the defendant's claim, at the same time. Before you file, double-check everything. Ensure all names are spelled correctly and all sections are complete. Accuracy is paramount. Filing court documents almost always involves a fee. The cost to file a defense and a defendant's claim, if you have one, is set by the province and can change, so it's wise to check the current fee schedule on the court's website. You can typically pay by credit card, debit, or cash. If paying this fee would cause you significant financial hardship, you may be eligible to apply for a fee waiver. This is a formal request to the court to allow you to file your documents without paying the required fee. You will need to provide detailed financial information to support your application. After you file your defense, the court clerk will provide you with stamped copies. One of these copies is for your records. The other is for the next critical step, service. You will also need to prepare a Form 8A, the Affidavit of Service. This is a sworn document that you will complete. You have successfully served the plaintiff, and it acts as your proof to the court that you followed the rules. Just as you were formally served with the claim, you must now formally serve the plaintiff with your filed defense. This step, called service, ensures that all parties have copies of all documents filed with the court. You must serve your defense on the plaintiff within the same 20-day window you had to file it. There are specific rules about how you can serve documents. You can use personal service, where you or another adult acting on your behalf physically hands the document to the plaintiff. You can also use alternatives like leaving a copy with an adult at the plaintiff's residence or sending it by mail, courier, or fax, provided there is a record of delivery. It is crucial that you serve the document correctly and then immediately fill out and swear the Affidavit of Service, Form 8A. This affidavit, which must be signed in front of a lawyer or a commissioner for taking affidavits, is your proof that you served the plaintiff. You will then file this affidavit with the court. Without this proof of service, the court may not consider your defense. Once the defense has been filed and served, the court will schedule the next step, a mandatory settlement conference. This is not a trial. It is an informal meeting led by a deputy judge or a mediator, and its primary purpose is to see if the dispute can be resolved without needing a full trial. This is a critical opportunity. You must attend, and you must come prepared. Before the conference, take time to review your entire case, the plaintiff's claim, your defense, and all your evidence. Prepare a brief, clear summary of your position. Think about what you are willing to negotiate. What would be an acceptable outcome for you? Could you agree to pay a smaller amount? Is there a non-monetary solution? Many cases are successfully resolved at the settlement conference. It saves time, money, and the stress of a trial. Go into the meeting with an open mind. Be prepared to listen to the other side, and be ready to negotiate in good faith. A successful negotiation can bring the entire matter to a close. What happens if you can't reach an agreement at the settlement conference? If a resolution isn't possible, the deputy judge will help set the stage for a trial. They may make orders to ensure both sides are ready, such as setting deadlines for disclosing all evidence and witness lists. It is vital that you comply with any orders made at the conference. The prospect of a trial can be intimidating, but it is simply the final step in the process. A trial is a formal hearing where you and the plaintiff will each present your evidence and witnesses to a judge. The judge will listen to both sides, review the evidence, and then make a final, binding decision. Preparing for trial involves organizing your exhibits, preparing your own testimony, and planning the questions you will ask the plaintiff and any witnesses. Courtroom etiquette is important. You will be expected to address the judge as Your Honor and conduct yourself professionally at all times. While most cases settle before this stage, it's important to understand that this is where the process ultimately leads if no agreement can be reached. Let's quickly recap the journey. You received a claim, but you didn't panic. You carefully read it, and most importantly, you immediately calculated and marked your deadline. You gathered your evidence, organized your facts, and drafted a clear, professional defense. You successfully filed it with the court and served it on the plaintiff, completing an affidavit of service as proof. You are now preparing for the settlement conference, ready to negotiate but also aware of the steps leading to trial if necessary. The most common mistakes defendants make are ignoring the claim, missing the deadline, or writing a defense that is emotional rather than factual. By following these steps, you have avoided those pitfalls and put yourself in the best possible position to be heard. Navigating the court system can be complex. While this guide provides a framework, every case is unique. If at any point you feel overwhelmed or unsure about your rights and obligations, we strongly encourage you to seek advice from a lawyer or a licensed paralegal in Ontario. They can provide guidance tailored to the specific details of your situation. You've taken the first steps, and by staying organized and informed, you can face this process with confidence.